So we'll continue with discussions on landmark cases 2022. Okay, the first one that we have is again recently decided relating to EWS reservations, economically weaker sections of the society. For them, whatever reservation is given, is that reservation constitutional or not? Right. So under Constitution also we have provisions relating to reservation. So when this new reservation has been introduced, is this reservation constitutional or not, or is it going against the basic feature or other principles of the Constitution? So it's a case before the apex court, and the main question was whether EWS reservation is constitutional or not. There were some 4 or 5 issues that the bench had to decide. Okay, and this was decided by a constitutional bench consisting of 5 judges. These are the judges, 5 judges bench. They decided this matter in 3:2 ratio, as in 3 were of one opinion and 2 were against that opinion. So this majority decision will prevail. They gave a decision in this particular case. Now, when we say that EWS reservation, it was introduced at a later stage. Initially, the provision was not there in Constitution of India. So when we want to add something new, we take help of this particular provision, right? Part 20 of Constitution, which deals with amendment of the Constitution. When we want to make some changes in the existing provisions, we want to omit something or we want to insert something which is completely new, this is the provision that becomes applicable. So it is nothing but power of Parliament to amend the Constitution and the procedure thereof. As in, the power is given to the Parliament. Even though we have one single constitution for states and union territories like the entire India, power is given to Parliament only. This power cannot be exercised by the state legislatures, right? So Parliament is given this power that they can amend, they can make changes in the existing provisions of Constitution, because with time law also should evolve. Right? In Constitution, whatever provisions are there, we need to make some changes so that it still remains relevant for us. And while doing that, what is the power of Parliament? To what extent they can go? Fine, they can make changes, they can bring new provisions also, they can remove existing provisions also. But what is the extent of that power of Parliament? So regarding that also, we have many cases that discusses about this limitation. What is the limitation that Parliament is having in terms of amendment of the Constitution? So it's just that Parliament can make changes in any provision of the Constitution, but one thing that they cannot change is that they cannot alter. Okay, they cannot alter basic feature of the Constitution. Without changing the basic structure or basic feature of the Constitution, Parliament is having power to make any changes that is needed. Okay, so when we talk about this reservation policy also, it was added by way of a Constitution Amendment Act. It is Constitution 103rd Amendment Act of 2019. Now, whether it's Constitution or some other legislation that you are reading, right? Mostly what we do is we refer the barracks. Barracks are easily available online. we refer the barracks, or even if you are like buying a hard copy of the barrack, what might happen is with time, right? With time, there are some changes that take place, some amendments that take place, right? Many a time you would see that the eggs which are available, the barracks which are available online, right? That might not be the updated version of it. Okay, like if you see this one, this Amendment Act was introduced in 2019. Now it's almost 2022 is also ending, but still most of the barracks that you will see online, right, they are not having this provision added. Like these are not the updated ones. So whenever you know that there was this certain amendment which took place while downloading the barrack, right, you can always cross-check or verify whether they have added it or not. You will get to know if it's the latest version or not. So if you look at Article 15, basically changes were made in Article 15 and 16. A new clause was added, clause 6. So if you see, that is not being added here. Okay, so this is not a latest version. So when you are not getting the latest version of it and you know that there was this certain Constitutional Amendment Act by way of which a certain amendment was made, right? So you can you can look for that particular Amendment Act, like a copy of that also you will get, PDF copy. And from here you can see what were the changes introduced by it. Same ways, whatever amendment you are reading, maybe 42nd Amendment, 48th Amendment, whatever amendment you are reading, you can look for this original copy and there you will get all the details over here. So what were the changes that were introduced by this Amendment Act? It inserted a new clause. Okay, so after clause 15, clause 5, there is a new subclause which was being added, that is clause 6. Same ways, for 16 also, a new clause was inserted. Okay, and what is this new clause all about? It is what is providing for reservation, EWS reservation. Okay, so it was January 9th when Parliament enacted this Constitution 103rd Amendment Act of 2019, and it inserted two main provisions, two subclauses, 15 clause 6 and 16 clause 6 in the Constitution. Now these are not added in most of the barracks, so you can refer this particular document where the entire clause has been provided. Okay, when you look at Article 15 and 16, what are Article 15 and 16? It's part of fundamental rights that are guaranteed to us. Under Part 3, fundamental rights, these are some rights which are guaranteed to us. Article 15 is relating to, in general, there should not be discrimination. Okay, it has not specified in what area, what specific field or matter, it's in general. In general, no discrimination should be there based on these grounds that are mentioned. And when we talk about Article 16, it's specifically related to matters of public employment. As in, when it comes to public employment, opportunity should be given equally to everyone. As such, there should not be any discrimination that people belonging to this certain thing are not entitled to appear for the exam. Right? So that those kind of discrimination should not be there. So these are the two provisions which we were already having. And under these provisions, there is a mention regarding reservation as well, right? That the state shall not be prevented from making special provision by law, as in reservation can be given for advancement of socially and educationally backward classes of citizens, SCs, STs. Their provision is available already, right? In matters of public employment also, reservations are there. So now why this Amendment Act was introduced? It was introduced in order to provide reservation to economically weaker sections of the society who do not fall under the reserved category. So under this new clause, 15 clause 6, which is mainly related to educational institutions, it enables the state to make special provisions for advancement of any economically weaker section of the society. Now, who is economically weaker section? Who will fall under this particular section of society? That is also been specified, right? Like family income should not be more than 8 lakhs in total, then they should not have this sort of a land, that sort of a thing. There are certain criteria. If a person fulfills all those criteria, it would be considered that this person falls under economically weaker section of the society. That person can apply for EWS category certificate and then get the benefits of reservation. So when we talk about Article 15 clause 6, it deals with reservation in educational institutions. That whether it's an aided institution, aided by the government, or it is an unaided institution, reservation will be given to economically weaker sections of the society. Okay, and there is a percentage as well, which is being fixed over there. So what is the percentage? It is 10%. Okay, up to 10% reservation may be there over here. This is Article 15 clause 6 of the Constitution. Okay, so this reservation is available for educational institutions. Now it will be applicable for educational institutions, whether aided or non-aided. But under Constitution, we also have a provision. Okay, we also have a provision relating to minorities. As in, minorities are given a right that they can run and open educational institutions of their own choice under Article 30 of Constitution. Educational and cultural rights, if you remember, that right is also been provided. So under that, what happens is we have a provision. See, educational and cultural rights, Article 30, that all minorities are being given a right to establish and administer educational institutions of their choice, right? They can establish and they can do whatever is needed for those educational institutions to be functioning. Now, what this provision says is that whether aided or unaided, this reservation would be applicable. But if an educational institution is established by a minority community as per provisions of Article 30, this reservation will not be applicable. So maximum limit for which this reservation would be provided is 10%. Right? 10% of seats may be reserved for EWS category people. Now, where this problem arose, right? This particular constitutional amendment, like we were already having reservations, those reservations are still applicable. What is the problem in providing for additional 10% reservation? Right, so this main problem is because this 10% ceiling is independent of ceiling on existing reservation, as in whatever reservations are already applicable, already available, there is a ceiling, as in there is a maximum limit to that it should not increase more than 50%. Okay, as of now we have some 49.5 some percentage reservation for different classes, different categories. So what happens here is this additional 10% if we are providing, that is an independent ceiling. That 49.5% will remain as it is. Apart from that, an additional 10% we are providing, as in it's somewhat around 59.5% reservation that we are providing. Okay, and another problem is that this additional 10% of seats, right, which are there, these will be applicable only for people belonging to economically weaker sections of the society who are from the unreserved category. As in, if someone from SC, ST, OBC, they are also earning less than 8 lakhs rupees, they will not get these benefits because already provisions are there, right? Already there are provisions for their reservation. So this particular reservation is only applicable for the unreserved category people. So there this main problem took place, because before reservation what happened, this was open for anybody, right? These remaining seats were open for anybody, but now from that also 10% seats are reserved specifically for economically weaker sections of the society from the unreserved category. So this is Article 15 Clause 6 that deals with educational institution, reservations in educational institutions. Another provision that was added is Article 16 Clause 6, which is relating to appointments. Now, when we say appointments, it is public employment, right? Public thing that is provided under Article 16 of the Constitution. So in matters of public employment, there should be equality of opportunity, and in that also we will be providing 10% reservation to the economically weaker section from the unreserved category people. So this is Article 16 Clause 6 that will enable the state to provide reservation up to 10% in addition to whatever existing reservations are there. Now, because these seats were not available for anybody who falls under that particular EWS category, it's only for those who are from unreserved category, plus they are meeting those other criteria, not more than 8 lakhs rupees, family income per year, and few other criteria regarding land and stuff, right? So because of that, 20 petitions were filed challenging constitutional validity of this Amendment Act in itself. That this Amendment Act is not valid. This is constitutionally not valid, because what is happening is it is not treating, there is a concept, okay, treat equals should be treated equally. There is a concept that equal should be treated equally. If somebody is not equal, right? If somebody is not equal, then for them, different provisions may be made, and that is as such not unconstitutional or anything. This is like a correct step only. Okay, so this is the provision that equal should be treated equally. If somebody is unequal, for their upliftment, you can make special provisions as well. Now, what happened here is that, fine, if you are mentioning that 8 lakhs rupees per income is the criteria, right? 8 lakhs per annum is the criteria. There are few other also regarding property and all, but just take this as an example, that family income should not be more than 8 lakhs rupees. Why is it that it's applicable only for the unreserved category? Why is it that it's applicable only for unreserved category? Because even from SCs, STs, or from OBCs, there may be people who are earning below this particular income. So if they are equal, if they are under the same thing, right, they are also earning this much, they are also earning this much. So why are we not including these people in this reservation? 10% reservation, why are we not including these people? That was the main problem over here, right? That it is only applicable for the unreserved category, and there many of the petitions challenge that it's not like equality, it's going against provisions of equality, it's going against basic feature of the constitution in itself. So as a result, in order to challenge constitutional validity of this particular amendment act, petitions were been filed that it is violating basic feature of the constitution, it violates fundamental right to equality under article 14. Same earning capacity people, others are not included, only unreserved are included, so it's going against article 14 of the constitution. So main arguments that were made before the court is that reservation cannot be based solely on economic criteria. Only on the basis of economic criteria, that if you are earning below this much, you will get reservation, that is not like a valid ground for reservation. Also, they said that SCs, STs, and OBCs, they cannot be excluded from this economic reservation. Just because they are having other reservations, it do not mean that they can be excluded from this economic reservation, because it will violate fundamental right to equality. Whoever is earning that same amount, they should be treated equally. If not, it is going against fundamental right to equality. Also, there was a previous case in Rasani, so where it was mentioned that whatever reservations we are having, right, it should not exceed more than 50% of the seats. As in, whatever openings we have, whatever seats we have, more than 50% should not be reserved. It should be less than 50%. There is like a maximum limit that is being put, that is ceiling limit. So there also we had this provision that the ceiling limit they are crossing, right? More than, along with this 10%, 50%, additional 10% you are providing. As in, you are exceeding this ceiling limit to provide 10% reservation to the economically weaker sections of the society. Okay, imposing reservations on educational institutions that do not receive state aid violates fundamental right to equality. Another problem is that you are imposing reservation on educational institutions which are not even receiving any fund from the state, right? Non-aided institutions, you should not impose these kind of reservations. So those were the grounds based on which petitions were filed. So before this reservation came, right, economically weaker sections, it was around 49.5% of seats which were already reserved for different categories or different classes of people. Along with that, there was another 10% reservation added by this Constitutional Amendment Act. So now what happened is petitions were being filed, it was heard, and initially, right, when the case was filed, then it was decided that it will be referred to a constitutional bench of the Supreme Court of India. Okay, and based on that, a 5 judges bench was also constituted. Last time we saw what this constitutional bench and different benches are, right? We have different benches of Supreme Court of India based on the number of judges who are deciding the matter. Like we have a single bench, we have a division bench, we have a constitutional bench, which is not less than 5 judges, as in 5, and it can go up to any number of judges. So for this matter also, a constitution bench was constituted of 5 judges to decide on the matter, and the main issues were these. Okay, these are the main issues, that if reservations can be granted solely on the basis of economic criteria. So whenever a case is filed, right, framing of issues is like a very important matter. Like the parties who are filing the case, they will write a long story of what happened, right? This happened, that happened, my right got violated, this, that, and everything. Out of that entire petition, issues will be framed, that what are the main questions that we need to decide, what are the main questions that we need to answer, like that issues will be framed. So here also there are 3 issues that were framed by the court. So these were the issues. First of all, if reservations can be granted solely on the basis of economic criteria, only on the basis of economic criteria, that you are earning below this much as a family, so you fall on, you will get the benefits of reservation. Is it valid or not? That was the first question. Secondly, if states can provide reservation in private educational institution which do not receive government aid as provided in the amendment. We are talking about both aided and non-aided educational institutions. Only minority institutions are being excluded. So is it proper or not that we are providing reservation even for private educational institutions which are not receiving aid from the government? Next one is that if EWS reservations are invalid for excluding SCs, STs, and OBCs and socially and economically backward classes from its scope, just because other reserved categories are not included in this 10%, is it violative or not? Is this reservation valid or not? Because it is excluding all those other categories of people who are included in some or the other type of reservation. So these were the main issues that were to be discussed, and this constitutional bench delivered its judgment on 7th of November 2022, and the majority decision was that this particular amendment as well as the reservation, EWS reservation, these are constitutionally valid. Okay, so there was this majority judgment. Majority view was of 3 judges and minority was of 2 judges, including Chief Justice of India. So this matter was decided accordingly, 3:2 ratio. 3 were in favor of this amendment. They held that it is constitutionally valid. 2 were against it. So majority judgment, as in those 3 judges who decided in favor of EWS reservation, they were of the opinion that reservations held singularly on the basis of economic criteria does not violate basic structure of constitution. What is the purpose of reservation? Right? Purpose of reservation is that we want to take some affirmative actions. We want to help a certain class or section of society in their upliftment. Right? So over there, what happens is only on the basis of economic criteria, if reservations are provided, that is as such not violating the basic structure of constitution, because we are trying to uplift that section. We are trying to make them equals with the remaining people. They also held that this breach of 50% ceiling limit by EWS reservation also does not violate basic structure. Earlier it was said that 50% should not be exceeded. Whatever reservations you are providing, it should not exceed 50%. But in addition to that, if 10% reservation is provided for upliftment of this economically weaker section from the unreserved category, that is not violative of basic structure. That is also, there is nothing wrong in that as well. Okay, so as per this majority judgment, as per the majority decision, reservation is an instrument of affirmative action, as in state is taking some positive steps in order to ensure upliftment of a certain class or section of the society. So as such, it's not needed that if we are providing reservation for economically weaker section, we should include all those SCs, OBCs, or STs, everybody. It is not needed. Okay, so that was what this decision is all about, that this reservation is valid. It is constitutionally valid. It's not going against provisions of basic structure or basic feature as well. So that's how the decision was given. Majority decision that prevailed was given. But after few days, right, Congress leader, there was this review petition being filed challenging this particular decision. So we are yet to see what will happen in this particular review petition that is being filed. So this review petition, it sought a review on whatever decision was given on 7th of November, saying that constitutional amendment is also valid, EWS reservation is also valid. So for that, a petition has been filed. We will come to know what is the decision at a later point in time. Right, so this is all about this particular case, economically weaker sections reservation, whether it is valid or not, decided by a 5 judges constitutional bench. 3 major issues were decided and majority decision was in favor of the amendment and in favor of the EWS reservation as well. Okay, so this is about it. We already discussed the hijab case. We'll see one more, okay? Okay, so this one is also a case decided in 2022. Okay, this was also decided. So now what is this case all about? This is relating to check bounce. Okay, we all know, right? Checks are being issued for a lot of different purposes, a lot of different business transactions as well. Right? Checks are commonly being issued. That check will be given. A certain date also will be mentioned over here. And you need to deposit the check within 3 months from this particular date to get the money. After 3 months, this check will expire. Okay, so what is this case all about? There are 2 parties, TRL Krosaki Refactories Limited versus SMS Asia Private Limited. So what happened here is SMS Asia, that is respondent in this particular case, right? SMS Asia, what they did is they had issued 7 checks in together, like in all together 7 checks they had issued to the appellant, as in petitioner, right, who had filed this appeal, TRL Krosaki Limited. So in a business transaction, this certain company issued 7 checks to TRL Krosaki Refactories Limited, and total amount was 1 crore 10 lakhs rupees in those 7 checks. Okay, so checks were being issued, date was being mentioned, and total amount was this. In a business transaction, these were issued. Now, when we issue a check, what happens is we need to go to the bank, we need to deposit it, only in that case, check will be clear. Right? If we are sitting at home keeping the check with us, bank will not know that check is being issued. We need to go to the court, present it in the bank, then only money will be issued. Same ways, TRL Krosaki, they also deposited these checks, 7 checks, they also deposited it in the bank. But what happened is that it was dishonored. As in, when they deposited the check, this amount of 1 crore 10 lakhs rupees was not given to them, but it was returned. Checks were returned with a comment or with an endorsement. So what was it? They said that account closed. As in, whatever account, from whichever account this amount had to be debited, right? That account itself has been closed by SMS Asia. They issued these 7 checks, they closed the account, and after this appellant deposited the checks in the bank, he came to know that this account is already being closed. So these kind of things mostly happen, okay? Account may be closed. Sometimes whatever amount is mentioned, maybe they are not having that much money in the bank itself, in the bank account itself. There also check will be returned. Sometimes maybe signature of the person is not matching. There also it will be returned. Sometimes the person may issue the check and later on inform the bank that if this gets deposited, do not clear it. Right? Based on such instructions also it gets dishonored. So like that, there are several situations wherein a check may be dishonored. In this case, it was because account itself was closed. Account was not in operation. Now, when a check is dishonored, right, what happens is we cannot straight away file check bounce case. Even though we say check bounce case is filed and all that, straight away we cannot file a check bounce case. We need to give notice to the party. Okay, we need to give demand notice to the other party that you had issued this particular check. I deposited it in the bank and it got dishonored because of so and so reason. So you give me the amount within this particular date. Otherwise, I will file a check bounce case in the court. Okay, that's the procedure that we need to follow. Here also what happened is the person gave a demand notice, but it was also not entertained. Okay, so what happened is that they ultimately filed the case. For check bounce cases are filed in magistrate court. So in magistrate court, the person approached and he filed the case, and cases are filed under this particular legislation. Negotiable Instruments Act 1881, and these are the 2 sections under which cases are filed. So here also, before subdivisional judicial magistrate case was being filed, and subdivisional judicial magistrate also thought that yes, this particular company had deposited the checks, it got dishonored, the person did not receive the money, the company did not receive the money, so they entertained the matter. Okay, based on the complaint, they started to proceed with it. They took cognizance of the complaint. Cognizance as in they took notice of the matter. They recognized it and then they started with the process basically. Right? So magistrate court also took cognizance of the matter and they issued summons to the respondent. They informed the respondent that this case has been filed against you and you need to appear before the court on so and so date. And when summons were issued, this other company, right, SMS Asia Private Limited, they came to know that, okay, fine, the checks got dishonored. The other company came to know that we have closed the account and they have filed a case against us. So what we should be doing? right? What we should be doing? Should we be appearing in the court, or we have some other option? So what they came up with is that they approached High Court of Orissa. Okay, they went to High Court of Orissa and they filed another case under section 482 of Code of Criminal Procedure. So what is section 482 is basically if an FIR is being filed, okay, if an FIR is being filed, or if a case is being filed, or some order or judgment is passed against a person, and the person is not happy with it, the person feels that maybe this FIR is not based on genuine grounds, maybe this order is not proper, maybe this case is not proper. Okay, in such cases, the person can approach the High Court and ask the High Court that please quash this particular FIR, quash this certain proceeding, right? Stop this particular proceeding. Like that, they can approach. So same thing was done by this company also, SMS Asia. They went to High Court of Orissa and they said that this particular complaint which is being filed, that is not proper, because it is not filed in name of the company, but it is filed in name of the general manager accounting only, as in name of an employee. In the name of an employee, this case is being filed, but we had issued the checks in name of this company only. So company should be filing the case. How come general manager accounting has landed in this entire matter? He is not having any right or ground to file the case. So this particular complaint should be quashed. Magistrate should not proceed with it. So that was the matter, and High Court also felt that okay, fine, they are right only. How come general manager is coming here? It is not proper. Okay, so it was decided that yes, general manager is not the right person to file this case. So the magistrate court should not take up this matter. Now this other company, right, TRL Krosaki, already they did not get the money. Checks were dishonored. Now there was a restriction in the case which they filed also, right? After all of these things happened, they decided to approach the Supreme Court of India. Okay, they decided to approach Supreme Court of India, and they said that even though we have filed the case in name of managing director, he is the authorized person. Okay, he is the authorized person. So whatever order was passed by Orissa High Court, that order is not proper. You need to set it aside. This order is not proper. This order is not valid. Okay, so in case of companies, right, there is something called as special power of attorney, like that. One person may be authorized, may be given some authority. All right, so take for example, there are two owners of a company. Two owners are there and they decided that, okay, fine, we already have a lot of work. What we will do is that we will appoint one of our employees. Okay, we will give special power of attorney to one of our employees. This person can represent us. This person can represent the company by signing, by putting his signature in some agreements, contracts. He can file complaints also. He can file cases also, everything. We are giving him this special power that he can represent us by putting his signature. Okay, so when this kind of special power of attorney has been given, then what happens is this person gets the authority. So if the general manager is also given this kind of an authority, then what happens is general manager is entitled to file a case. It's not needed that you need to file a case in name of company. He is authorized person. These kind of things you would mostly see when cases are filed in name of company. Some directors, CEOs, or somebody else who is authorized, they might also be included as a party. So under these kind of special power of attorney, lot of powers are been given. Company seal would be put, and then witnesses will sign, and then this entire matter will happen. Now here what happened is, this company approached the Supreme Court that we had authorized general manager to do all these things on behalf of us. Right? So how come the High Court has said that, okay, fine, this case is not valid, magistrate should not take an action. Right? So they approached the Supreme Court of India. Now what happened, what Supreme Court said is that Supreme Court was of the view that when a company is payee in the check, as in company's name was mentioned in the check, based on which this complaint was filed, complainant necessarily should be company which would be represented by an employee who is authorized. Complainant will be company only, but it may be represented by an employee also. So there is nothing wrong if the general manager files a case. There is nothing wrong in it because general manager was authorized to file cases and do a lot of other things on behalf of the company. Okay, so this case tells us about this special power of attorney. Also, it tells us about what check bounce case is all about, and also this provision, right? 482 of CRPC. Lot many times you will come across this provision when you are reading this latest decisions. Lot many times people approach the High Court saying that please stop this certain case or quash this certain FIR, this particular order is not valid, and so many other things. All that power comes from 482 CRPC, and it is given to the various high courts. Okay, is this case clear? Okay, so this is the amendment which I was talking about. You can go through it. You can save this. You can save this link. Okay, and one more case we are going to discuss. For that, you can refer this particular link. Okay, so this is the third case that we will be discussing, and this is not before Supreme Court or High Court, but what is it? It is before Consumer Forum. Okay, we have a legislation, right? Consumer Protection Act. Under that particular act, certain forums are being established, that in district, in states, as well as a national forum. In Delhi, there is a forum is being established that if you are not happy with some goods or services that you have purchased, you need not simply suffer. You can file a case and you can ask for adequate amount of compensation. Okay, so that is called as consumer forum. We have three different forums at three different levels: district, state, and national. So this particular case was before the District Consumer Dispute Redressal Forum, Bangalore. All right, what is it? It is filed by Madhusudana B versus Think and Learn Private Limited. So when we say Think and Learn Private Limited, what is it? It is Byju's, that app which we know, right? Byju's app, it was against them that this case was being filed. Now, what was it all about? When we see Consumer Dispute Redressal Forum, as in they might have taken some goods or services from this particular company, and they were not happy with the product or the service or the goods that was being offered, so they filed the case. So this is the final order which is available online. Okay, I just downloaded the order and I have shared the link. You can save it. You can read in your free time as well. So this case was filed in 2021 and it was decided in 2022. May 10th May 2022, decision was given. This is the final order or judgment. As in before that also certain orders might come. Those also are available. If you look for this case number red, you will be able to find it out. Now what happened here is that this person, right, Madhusudna B, he was approached by a representative of Byju's and he was offered this learning platform, right? They would sell certain courses, right? That this particular course is there, you will get this app. On the app you can see and all of that. So what happened is that this petitioner, he filed a complaint against Byju's under Section 35 of Consumer Protection Act because of deficiency of service in not providing proper learning app for students. Whatever app was promised, whatever platform was promised, it was not based on the promise. There was deficiency in the service. Okay, and he was charged 99,000 rupees. So what he asked is that you return this 99,000 rupees plus interest, because I had, I would have otherwise earned interest on this money. So you need to return this 99,000 rupees plus interest along with a compensation of 50,000 rupees because you caused harassment and also you wasted my time. So a total of 1,50,000 rupees you need to pay in return of this 99,000 rupees purchase that I had made, because there is deficiency in service. Your services are not proper. Okay, case was filed before the consumer court. Now, when a case is filed by the petitioner, court will inform the respondent, right? Court would ask the respondent that you need to appear, you need to give your point, and you need to give your defense mainly, right? But what happened is Byju's was not appearing in the court. Okay, Byju's was not appearing in the court, and that is why decision was given ex parte. You can note it down, okay? Ex parte, this is a term which is being used to mean that decision in the case is given in presence of one of the parties only. As in, if you are filing a case against Byju's, Byju's is not appearing, it will not happen that court will be waiting forever for Byju's to appear. If they are not appearing means court can give a decision ex parte also in absence of them, that we asked them to appear, they did not appear in the court, so in their absence only we are giving a decision. Okay, so it is called as ex parte decision. So here also, because Byju's was not appearing, even though court had issued summons, what they did is they passed an order ex parte. Now, what was this matter all about? The main problem was that while they took this particular course from the learning app, right, and they paid 99,000 rupees, they were promised that you will be given 2 tablets. Okay, you will be given 2 tablets worth 25,000 rupees, and in those tablets you can use this learning app. Okay, in those you will be able to use the learning app. But actually they were provided with some other tablet which was around some 15,000 rupees only. So this person was not happy that whatever was promised in starting of making the purchase, that is not being done. So if you are not providing me tablets of 25,000 rupees, why did you charge 99,000 rupees? That was the main matter all about. So what order is being passed by the court is that court ordered Byju's that you need to refund this entire amount of 99,000 rupees to the complainant, plus not just this amount, you also need to pay interest of 12% per annum from the date of receipt of the same amount. Right, so the purchase was made in 2021 only. Order came in 2022. So until you make the payment till that particular date, you need to pay 12% interest as well. This is something which is very common. Even if court provides some compensation and all, right, court would say that interest also would be applicable. Whenever you are paying until that date, interest also would be applicable. So here also same thing happened. Apart from that, they were also directed, Byju's was also directed that 25,000 rupees you need to pay towards damages, because this person trusted you. They thought that you will be providing those 2 tablets. You did something else. So for that, you need to pay 25,000 rupees towards damages. The person had to go to the court and all that stuff. Plus 5,000 rupees towards litigation expenses. For filing the case also, he had to put some money as well. Right? So this entire amount Byju's will have to pay to the petitioner. And what petitioner will have to do is that when they receive this entire amount, they need to return the tablets that they received and they need to return it to Byju's. Okay, so this was the main matter, and also court will specify a time limit. It's not that, okay, someday, some year you return it. Court would specify some time limit. So what is the time limit fixed here is within 30 days from receipt of this order copy, right? You need to do it and submit a compliance report to this commission. Once you fulfill these conditions within 15 days, you need to inform the court also that yes, whatever order was passed, whatever directions were given to us, we have fulfilled that as well. So regarding that, you need to inform the court as well. Okay, so this is how the orders would be given in a certain judgment that yes, decision was in favor of this person only, and court gave some orders, not just to Byju's but to the other party as well. Right, Byju's should be returning the amount, but other party also should not be taking undue advantage. They should return the tablets that they received from the company. Right, so this is how the matter was decided. So Consumer Protection Act, under this, a lot of cases are being filed, and a lot of times you would see, even for like very small matters, parties would approach if their rights were being violated, and they actually give proper decisions, right? With a lot of these kind of things you would see. So this is one such case from 2022. Is it clear? Okay, and if you are interested, you can save this link. Okay, you can go through this part as well in your free time. There are like three different forums based on the amount of compensation that parties are asking, right? It would be decided which forum you should be approaching. Is it district forum? Is it state, or is it national? If amount is very small, it would go to district. If it's a little bit mid-range, it would go to the state. And if it's like a high amount, I think more than 10 crores or something, then it would go to the National Commission. So you can just search District Consumer Redressal Forum, you will get that as well. Okay, so fine, then with these 3 judgments, we'll end this class. Okay, you can save these 3 links and go through them in your free time. You can read the entire judgment as well. Okay, thank you everyone.